Chapter 24. Bona fide purchasers actual and constructive. NOTICE-FRAUDULENT grantees. SS 369. Rights of bona fide purchasers. As has been observed, creditors have an equitable interest in the property of their debtors, or in the means the latter have of satisfying the creditor's demands, which the law will under certain circumstances enforce, since the insolvent's property constituted the foundation and inducement of the trust and credit. But the interests of a bona fide purchaser of a debtor's property are superior to those of creditors, for the obvious reason that the former has not, like a mere general creditor, trusted to the personal responsibility of the debt but has paid the consideration upon the faith of the debtor's actual title to the specific property transferred. But the interests of a bona fide purchaser of a debtor's property are superior to those of creditors, for the obvious reason that the former has not, like a mere general creditor, trusted to the personal responsibility of the debt but has paid the consideration upon the faith of the debtor's actual title to the specific property transferred. In such a case, the interests of the general creditors are superseded or defeated by the purchaser's superior equity. It is merely a substitution of property. The value given or paid by the purchaser has taken the place of the property which he received. Hence, the rights of a bona fide grantee who has paid a full valuable consideration are protected. Though the grantor may have been actuated by a fraudulent intention, still, as we have seen, a grantee is not protected when he has not paid such a consideration, though he may have acted in good faith. The two must concur. If no consideration has been given, then there has been no substitution of property. The amount of the consideration is not necessarily material when the grantor is solvent, but when he is insolvent, the kind and amount of consideration become material and important, even in the absence of actual intent to defraud. Thus, an agreement to support an insolvent grantor may be a valuable consideration, but it is not sufficient to uphold a conveyances against prior creditors. Even though there may have been no actual intent to defraud, persons receiving a conveyance from a grantor for such a consideration must see to it that the existing debts of the grantor are paid, and it is immaterial that the consideration comprises a present sum of money paid in addition to the agreement for support, provided the money alone were palpably inadequate. Three things must concur to protect the title of the purchaser. He must buy without notice of the bad intent on the part of the vendor. He must be a purchaser for a valuable consideration, and he must have paid the purchase money before he had notice of the fraud. Chief Justice Marshall observes that the rights of third persons, who are purchasers without notice for a valuable consideration, cannot be disregarded. Titles, which, according to every legal test, are perfect, are acquired with that confidence which is inspired by the opinion that the purchaser is safe, if there be any concealed defect, arising from the conduct of those who had held the property long before he acquired it, of which he had no notice. That concealed defect cannot be set up against him. He has paid his money for a title good at law. He is innocent, whatever may be the guilt of others, and equity will not subject him to the penalties attached to that guilt. All titles would be insecure, and the intercourse between man and man would be very seriously obstructed if this principle be overturned. Dillon, J., in Gardner v. Cole, said that where the first conveyance originates in a fraudulent purpose, and is without any consideration of value, and the grantor remains in possession, and claiming ownership sells the property as his own to a party who buys without actual notice of the prior deed and pays value, the latter purchaser may avoid the prior voluntary and fraudulent conveyance. SS 370. Generality of the rule. A court of equity acts only on the conscience of the party, and if he has done nothing that taints it, no demand can attach so as to give jurisdiction. The rule is not limited to cases where conveyances are made in fraud of creditors, but applies to cases in which the vendor has been swindled out of his property by a vendee. For whenever the property reaches the hands of a bona fide purchaser for value, the rights and equities of the defrauded owner are cut off. A purchaser for a valuable consideration, without notice of a prior equitable right, obtaining the legal estate at the time of his purchase, is entitled to priority in equity as well as at law, according to the well-known maxim that when the equities are equal, the law shall prevail. If creditors condone the fraud, the grantee's title is good against all comers. SS 371. Mortgagee as bona fide purchaser. A mortgagee is a purchaser to the extent of his interest. New York has taken an advanced position on this question. It is held in that state that where property is conveyed to a voluntary grantee, and the latter, at the grantor's request, executes a mortgage upon the land to a creditor of the grantor to secure a debt of the grantor's which existed at the time of the conveyance, the mortgagee is a bona fide purchaser for a valuable consideration, And though the conveyance may be set aside by other creditors, the mortgagee will not be affected. The giving of the mortgage was regarded as merely applying the property for the benefit of creditors by rescinding the fraudulent transaction and entering into a new valid contract. As we have seen, the law does not deprive parties of the right to restore to its legitimate purposes property which has been fraudulently appropriated. SS 372. Without notice, Judge Story observes that it is a settled rule in equity that a purchaser without notice, to be entitled to protection, must not only be so at the time of the contract or conveyance, but at the time of the payment of the purchase money. On the other hand, it was said in a case which arose in Georgia that the purchaser at a sale made with intent to defraud creditors, if himself free from all responsibility for the fraud, was not affected upon afterward discovering the seller's fraudulent intent, even though he had not then paid the purchase money, and the notes given for it had not passed beyond the control of himself and the seller, it not appearing that he alone could control the notes without the cooperation of the seller, or that the latter could have been induced to cancel or surrender the notes, which were negotiable. In the United States, even in states where the statutes are a literal rescript of the English statutes of 13 and 27 Elizabeth, the general doctrine is that the right of the subsequent purchaser to avoid the first conveyance will depend on whether he had notice of its existence at the date of his purchase. This leads us to the consideration of one of the most important branches of our subject, the doctrine of notice as applied to covenant alienations. SS 373. Kinds of notice. Notice is of two kinds, actual and constructive. Actual notice may be shown to have been received or given by all degrees and grades of evidence, from the most direct and positive proof to the slightest circumstance from which a jury would be warranted in inferring notice. It is a mere question of fact, and is open to every species of legitimate evidence which may tend to strengthen or impair the conclusion. Constructive notice, on the other hand, is a legal inference from established facts, and like other legal presumptions, does not admit of dispute. Constructive notice, says Judge Story, is in its nature no more than evidence of notice, the presumption of which is so violent that the court will not even allow of its being controverted. Substantially the same language is employed by Mr. Justice Woods in Townsend v. Little. Chancellor Kent said, "I hold him chargeable with constructive notice, or notice in law, because he had information sufficient to put him upon inquiry." Constructive notice, said Wright, J., is a legal inference from established facts, and when the facts are not controverted, or the alleged defect or infirmity appears on the face of the instrument, and is a matter of ocular inspection, the question is one for the court. Constructive notice has been said to be of two kinds, that which arises upon testimony and that which results from a record. Actual notice is usually a question for the jury, and is to be established by implication or inference from other facts. There is no particular kind of evidence necessary to establish it. Anything that proves it or constitutes legal evidence of knowledge is competent. It is otherwise as to constructive notice. There the law imputes notice to the purchaser, and whether or not this will be done upon a conceded state of facts is not a question for the jury. SS 374. Constructive notice of fraud. The principles which govern and control the general doctrine of constructive notice of fraud as bearing upon our subject are not always entirely clear. Williamson v. Brown, already cited, contains an important review of the authorities by the learned Justice Selden as to the general subject of notice. Baker v. Bliss, where the question was as to whether or not a purchaser took with knowledge of the fraud affecting the title of his vendor, seems to clearly establish the rule that to charge a party with such notice the circumstances known to him must be of such character as ought reasonably to have excited his suspicion and led him to inquire. It appeared that the purchaser had paid a valuable consideration, and had testified, and the referee had found that he had no actual notice or knowledge of the fraud which rendered the conveyance void as against creditors, but that he had sufficient knowledge to put him upon inquiry, and that such knowledge was equivalent to notice, and in law amounted to constructive notice. Cases like Williamson v. Brown are cited and applied in the opinion. In Ellis v. Hallman, a Record Act case, Tracy, J., said, "Notice sufficient to make it the duty of a purchaser to inquire, and failure so to do when information is easily accessible, is equivalent to actual notice within the rule of the authorities." Page, J. Observed in Williamson v. Brown, a party in possession of certain information will be chargeable with a knowledge of all facts which an inquiry suggested by such information, prosecuted with due diligence, would have disclosed to him. In Reed v. Gannon, it appeared that the parties dealt upon the assumption that there were liens or encumbrances upon the property, but their number, extent, or character was not stated. Rapallo, J., said, the insertion of these clauses in the instrument was sufficient to put the plaintiffs on inquiry as to the extent and description of the existing encumbrances referred to. It was such notice as in the language of the authorities would lead any honest man, using ordinary caution, to make further inquiries. Constructive notice, says Haight, J. in Farley v. Carpenter, is a knowledge of circumstances which would put a careful and prudent person upon inquiry, or such acts as the law will presume the person had knowledge of, on the grounds of public policy, as, for instance, the laws and public acts of the government, instruments recorded pursuant to law, advertisements in a newspaper of a notice or process authorized by statute. Rapallo, J., said, the insertion of these clauses in the instrument was sufficient to put the plaintiffs on inquiry as to the extent and description of the existing encumbrances referred to. It was such notice as in the language of the authorities would lead any honest man, using ordinary caution, to make further inquiries. Constructive notice, says Haight, J. in Farley v. Carpenter, is a knowledge of circumstances which would put a careful and prudent person upon inquiry, or such acts as the law will presume the person had knowledge of, on the grounds of public policy, as, for instance, the laws and public acts of the government, instruments recorded pursuant to law, advertisements in a newspaper of a notice or process authorized by statute. SS 375, Roland Stearns v. Gage, the question of what constitutes notice of fraud, or of a fraudulent intent, is one of manifest importance to creditors and purchasers. Some apparent dissension has been introduced into this branch of the subject by a dictum of Miller, J. in Stearns v. Gage, followed by the New York Supreme Court in Farley v. Carpenter, and recently approved in Parker v. Connor. According to the court's own statement, it could not be claimed that any question as to constructive notice was presented upon the trial in Stearns v. Gage, and it seems unfortunate that the questionable sentences should have been embodied in the opinion. The court observed that actual notice is required where a valuable consideration has been paid. The statute relating to fraudulent conveyances in New York contains a provision that it shall not be construed in any manner to affect or impair the title of a purchaser for a valuable consideration, unless it shall appear that such purchaser had previous notice of the fraudulent intent of his immediate grantor, or of the fraud rendering void the title of such grantor. The court say that this plainly means that actual notice shall be given of the fraudulent intent or knowledge of circumstances which are equivalent to such notice. Circumstances to put the purchaser on inquiry where full value has been paid are not sufficient. No authority has been cited which sustains the principle that a purchaser for a valuable consideration, without previous notice, is chargeable with constructive notice of the fraudulent intent of his grantor, and such a rule would carry the doctrine of constructive notice to an extent beyond any principle which has been sanctioned by the courts, and cannot be upheld. It must be noted that the word actual is not embodied in the statute, but has been in effect interpolated by this construction. We dissent decidedly from the statement that the statute plainly means that actual notice shall be given of the fraudulent intent. Such a construction violates the settled rule that statutes of this character shall be liberally construed for the suppression of fraud. It is to be regretted that the utterances quoted occur in a case in which no facts sufficient to put a purchaser on inquiry, or to constitute what is often called constructive notice of fraud, were found or were actually present, had the court been confronted with such facts and compelled to squarely face the question. These remarks, which we consider unfortunate, might never have been made. It is idle to assail the case with violent language, as has more than once been done, but we should rather view the objectionable sentences as an unguarded utterance, and entertain the hope that the questionable features of the opinion will be hereafter limited and distinguished, and perhaps ultimately overturned. Plus, knowledge of circumstances which are equivalent to actual notice are regarded in the opinion as sufficient evidence of notice. This plainly implies that the court does not mean to require proof that as matter of fact the purchaser was informed personally of the debtor's or vendor's fraudulent intention, but leaves open the wide field of circumstances by which actual notice may be inferred, implied, and fastened upon him. In other words, circumstantial evidence will suffice. In Farley v. Carpenter, which follows and adopts Stearns v. Gage, the court at general terms say, a person may be chargeable with constructive notice and still have no actual notice. Fraud implies an evil or illegal intent. Such intent can only exist in case of knowledge. Under this statute, fraud is not a question of negligence. It is a question of knowledge and intent. A party may be negligent in not examining the records for liens and encumbrances on real estate before effecting a purchase, and still be strictly honest, and in no scent of fraud. We deny that fraud necessarily implies an evil or illegal intent. The transaction may be pure and honest as regards the debtor's mental emotions, or his belief, or when measured by his standard of morality, and yet be pronounced by the courts fraudulent and void in law. Nor is fraud always a question of knowledge and intent, because, by a fiction of law, knowledge is constantly imputed by statutes and by the courts in cases where it does not in fact exist, and no evil intent is present. SS 376. It seems startling if not preposterous to say that circumstances which ought to put the purchaser on inquiry are not sufficient to taint the transaction with fraud, or to warrant the conclusion that the vendee is not a bona fide purchaser. We submit that this statement is inaccurate and misleading. The confusion undoubtedly results in part from a failure to distinguish between circumstantial evidence sufficient to establish or justify a finding of actual notice of fraud and facts which raise the presumption of constructive notice. The facts and circumstances sufficient in either phase of the question to establish notice or bad faith in the vendee bear a close resemblance, if indeed they are not often identical. Hence the doctrine of Stearns v. Gage, if it is effectual for any purpose, is to be regarded as seriously impeding, if not breaking, the force of indicia and circumstances as evidence of guilty knowledge. What object is to be subserved in endeavoring to establish knowledge or notice of a fraudulent intent by proof of surrounding circumstances? If facts sufficient to put an honest man on inquiry count for nothing, or not facts manifestly sufficient to excite grave suspicions, at least evidence tending to prove actual notice is not a court or jury justified in finding actual notice from facts which should excite inquiry or raise a presumption of constructive notice. In short, is a court or jury justified in finding, as matter of fact, absence of actual notice in cases where facts sufficient to create a clear presumption of constructive notice are in evidence? Can such a verdict or finding be said to honestly reflect the evidence? It seems incredible that a party whose suspicions concerning the fairness and good faith of a transaction must have been excited by the exceptional and peculiar conduct of the parties can preserve the character of a bona fide purchaser, either by listless inattention and indifference concerning the indicia of fraud, or by active and positive efforts to avoid all knowledge of the true motive or design of the debtor. This would be offering a premium to vendees who masqueraded as mutes, or who declined to use their eyes and ears to discover the fraud, the evidence of which surrounded them on every side. Is not such a vendee guilty of a fraudulent turning away from knowledge? Must not a person who willfully closes his eyes to avoid seeing what he believes he would have discovered had he kept them open, be considered as having perceived or detected what any man with his eyes open would have seen? As a party who has eyes to be permitted to say that he saw not, and who has ears to be permitted to say that he heard not, when the warning signal has been sounded, and the attention of a party has been aroused, is it not incumbent on such party to stay his hand until he shall ascertain by the requisite inquiries the facts foreshadowed by the suspicious circumstances? In Farley v. Carpenter, the purchaser testified that he thought something was up from the way the debtor talked. He sent for me. He wanted to sell me his farm. I said, "What is up?" He said, "You need not ask any questions nor say anything for 2 or 3 days. When the warning signal has been sounded, and the attention of a party has been aroused, is it not incumbent on such party to stay his hand until he shall ascertain by the requisite inquiries the facts foreshadowed by the suspicious circumstances?" In Farley v. Carpenter, the purchaser testified that he thought something was up from the way the debtor talked. He sent for me. He wanted to sell me his farm. I said, "What is up?" He said, "You need not ask any questions nor say anything for 2 or 3 days. The court said it did not necessarily follow that he should infer that the debtor was designing to cheat and defraud his creditors and flee from the state. This case, it seems to us, is squarely opposed to Baker v. Bliss, and can scarcely be reconciled with the views of Rapallo, J., in a case to be presently noticed, in which he entertains no doubt that it is legitimate for the jury in such cases to consider whether the vendee had knowledge of facts pointing to a fraudulent intent or calculated to awaken suspicion, and the actual notice of a fraudulent intent on the part of the vendor need not be established by direct proof. The fact of notice or knowledge may be inferred from circumstances. The fact of notice or knowledge may be inferred from circumstances. Let the reader briefly consider this subject in its practical application and bearing. A debtor contemplating flight suddenly offers to sell his tangible property at a sacrifice for cash to a vendee who sees in the transaction the usual indicia surrounding fraudulent alienations, sufficient to put a purchaser on inquiry. No inquiry is made. The vendee takes title to the debtor's property, or, more properly speaking, to the creditor's trust fund, and provides the debtor with its equivalent in money which has no earmarks and is easily secreted or dissipated. And the latter absconds. Here the vendee has actually facilitated the consummation of the fraud by furnishing the debtor with a portion of its value in cash in consideration of receiving the property at a sacrifice. Is not the purchaser at least a quasi-conspirator in such a case, even though the debtor did not openly avow his fraudulent purpose? Imprudence or inattention to the suspicious circumstances may possibly be overlooked. But can willful blindness be pardoned? Again, suppose a deed is made for full value by a to-be, containing recitals or provisions which render it voidable as to creditors provided it is not solvent. In other words, its provisions stamp it as fraudulent in law or void against creditors upon its face if it is insolvent. The instrument is effectual between the parties, and is good against all the world if it was solvent. It is voidable as matter of law if it was insolvent. Do not these recitals cast upon be the duty of investigating and inquiring as to the solvency of it if no inquiry is made, and as matter of fact is insolvent? Do not the recitals of the instrument then constitute constructive notice to B of the fraud intended by A? The whole supposition of the case is that B had no actual knowledge or notice of the intended fraud. It is difficult to assign any reason why the doctrine of constructive notice, if it has any application to our subject at all, should not be applied in a case in which adequate consideration has been given. Where the fraudulent intent is present, proof of consideration will not save the transaction. It is merely a fact, a piece of evidence tending among other things to establish want of notice. But it clearly has no such controlling or overshadowing effect, and bears no such strong relation to the transaction as to justify the court in disregarding, as the basis of a finding of notice, proof of facts sufficient to excite inquiry or suspicion, or to constitute constructive notice. Indeed, actual or pretended payment of consideration is almost a necessary incident of a covenous transaction, and often serves as a convenient cover for fraud. SS 377, Carroll v. Hayward, Actual Belief. This question of notice, as applied to our subject, has frequently been up for adjudication in Massachusetts. Reasonable cause to know, said Ames, J., is evidence having a tendency, and generally a strong tendency, to prove that the party in question did know. But it is a mistake to say that it is the same thing as knowledge. What might convince one man might be insufficient to satisfy the mind of another. What might convince one man might be insufficient to satisfy the mind of another. Thus, in an action for deceit by false representations, the scienter must be proved and found as matter of fact, and it is not enough merely to prove that the party had reasonable cause to believe the representation untrue, and from that infer scienter as a question of law. The distinction between reasonable cause to believe and actual belief is pointed out in Coburn v. Proctor, SS 378, Parker v. Connor. The New York Court of Appeals again reverted to this general subject in Parker v. Connor, Baker v. Bliss, and Reed v. Gannon. Are there emasculated so that creditors can draw little aid or comfort from them, and Stearns v. Gage is considered sufficient to dispose of the present controversy. Rapallo, J., one of the ablest judges and clearest writers in the court, said, "We think that in cases like the present, where an intent to defraud creditors is alleged, the question to be submitted to the jury should be whether the vendee did in fact know or believe that the vendor intended to defraud his creditors, not whether he was negligent in failing to discover the fraudulent intent. The vendor's title and legal right of disposition are unquestioned, and the ground upon which the transfer is impeached is not any defect in the chain of title, but that the vendor's motive in selling was to hinder, delay, or defraud his own creditors. In such a case, there is no duty of active vigilance cast upon the purchaser for the benefit of creditors of the vendor, which should require him to suspect and investigate the motives of the vendor. If he knows or believes them to be fraudulent, he has no right to aid the vendor in his fraudulent scheme, and by so doing he makes himself a party to the fraud. But fraud should not be imputed by the application of the strict rules of constructive notice in such a case, and actual good faith should be sufficient to protect the purchaser. It will thus be seen that the dictum of Stearns v. Gage is adopted in a qualified sense. We respectfully urge that the proposed test, did the vendee in fact know or believe that the vendor intended to defraud his creditors, is limited, loose, uncertain, and unsatisfactory. The court proceed to state that on general principles, independent of the statute, the same rules are applicable in such cases as govern in determining the bona fides of commercial paper, viz., not whether the holder took the bill or note without exercising sufficient prudence and care, but whether it came into his hands under such circumstances as to charge him with receiving it mollified, and that unless he is fairly chargeable with notice of the fraud, even negligence will not defeat his title, while conceding that there is some plausibility in the reasons assigned for the non-application of the doctrine of constructive notice to fraudulent transfers. We bow to these decisions of the highest court of a great state with hesitation and reluctance. The great embarrassments under which creditors labor in overcoming the presumptions of legality and good faith which ordinarily inhere in all alienations and transactions of the debtor have already been considered. Proof of fraud is usually an Herculean task, and creditors should not consent without a struggle to be divested of so important and useful a factor in their litigations as the doctrine of constructive notice of fraud would be likely to prove. Before further discussing in the abstract what we consider the objections to the principles embodied in these cases, we will glance at the many authorities which tend at least to establish a more favorable rule for the creditor class. SS 379. Facts sufficient to excite inquiry. Let us notice the cases. In Bartles v. Gibson, Bunn, J., with whom Harlan, J., of the United States Supreme Court, concurred, said, the defendant testified that he knew that his brother was in some difficulty, and that the trouble was of a financial character. Whether he knew all or not, he knew enough to put him upon inquiry. If he had knowledge of facts sufficient to excite the suspicions of a prudent man and put him on inquiry, he made himself a party to the fraud. Chancellor Zabriskie. After stating that if the object of a debtor in making an alienation is to hinder and delay any of his creditors, the transaction may be avoided, if made to any one having knowledge of the intent, continues, this knowledge need not be by actual positive information or notice, but will be inferred from the knowledge by the purchaser of facts and circumstances sufficient to raise such suspicions as to put him upon inquiry. In Singer v. Jacobs, the court adopt the summary of Mr. Bigelow's as follows. If facts are brought to the knowledge of a party which would put him as a man of common sagacity upon inquiry, he is bound to inquire. And if he neglects to do so, he will be chargeable with notice of what he might have learned upon examination. If, however, there be no fraudulent turning away from knowledge which the res gesta would suggest to a prudent mind, if mere want of caution, as distinguished from fraudulent or willful blindness, is all that can be imputed to a purchaser of property, the doctrine of constructive notice will not apply to him. In Wilson v. Pruett, a suit brought to annul an ante-nuptial settlement, Woods, J., said, actual knowledge of the fraudulent intent is not necessary. A knowledge of facts sufficient to excite the suspicions of a prudent man or woman, and to put him or her on inquiry, amounts to notice, and is equivalent to actual knowledge in contemplation of law. It has even been held that the means of knowledge, by the use of ordinary diligence, amounts to notice. The judgment in this case was reversed, but upon the very excellent ground that the knowledge of the facts which the wife possessed rather dispelled than created any suspicion that the husband had a design to defraud his creditors. In Kansas, the court say, if the facts brought to his attention are such as to awaken suspicion, and lead a man of ordinary prudence to make inquiry, he is chargeable with notice of the fraudulent intent, and with participation in the fraud. In Bush v. Roberts, Gray, J., observed, the action could only prevail by proof that the purchaser had actual notice of a fraudulent motive on the part of the seller or knowledge of circumstances which was equivalent to such notice. If he knew, or had believed the motives of his vendor to be fraudulent, then, by aiding him in his scheme, he made himself a party to the fraud, but no evidence is competent proof to affect him, or his right to the possession of his property, which falls short of proving the nature of the transaction and of illustrating the guilty participation of the vendee. SS 380. Swain, J., in delivering the opinion of the United States Supreme Court, said, a sale may be void for bad faith, though the buyer pays the full value of the property bought. This is to the consequence, where his purpose is to aid the seller in perpetrating a fraud upon his creditors, and where he buys recklessly with guilty knowledge. In a controversy in Alabama, it is said that participation by the grantee may be proved by any circumstances sufficient to charge his conscience with knowledge or notice of the fraudulent designs of the grantor. In a recent Maryland case, this language occurs. All that was necessary to make him take subject to the fraud was sufficient knowledge of the suspicious circumstances to put him on inquiry. In David v. Burchard, where a mortgage was attacked, the courts say that this knowledge need not be actual positive information or notice, but may be inferred from the knowledge of the mortgagee of facts and circumstances sufficient to raise such suspicions as should put him on inquiry. In DeWitt v. Van Sickle, the court observed, a person who deals in the avails of a scheme to defraud creditors To keep what he gets, must not only pay for it, but he must be innocent of any purpose to further the fraud. Even to protect himself, actual notice need not be shown if the purchaser has before him, at the time of his purchase, facts and circumstances from which a fraudulent intent, either past or present, on the part of the vendor, is a natural and legal inference, or such facts or circumstances of suspicion as would naturally prompt a prudent mind to further inquiry and examination, which, if pursued, would lead necessarily to a discovery of the corrupting facts, he is chargeable with notice. In Pruitt v. Wilson, the court observed that the grantee to vitiate the transfer must be chargeable with knowledge of the intention of the grantor, not that explicit and direct proof of actual knowledge must be adduced. In Hopkins v. Langton, Chief Justice Dixon said, knowledge by the vendee of the fraudulent intent, or the existence within his knowledge of other facts and circumstances naturally and justly calculated to awaken suspicion of it in the mind of a man of ordinary care and prudence, thus making it his duty to pause and inquire, and a wrong on his part not to do so, before consummating the purchase, is essential in order to charge the vendee. The vendee cannot shut his eyes, but must look about him and inquire, whatever is notice enough to excite attention and put the party on his guard. And call for inquiry is also notice of everything to which it is afterwards found that such inquiry might have led. When a person has sufficient information to lead him to a fact, he shall be deemed conversant with it. There must be some reason to awaken inquiry and direct diligence in the channel in which it would be successful. That is what is meant by reasonable diligence. The presumption is that if the party affected by any fraudulent transaction or management might, with ordinary care and attention, have seasonably detected it, he seasonably had actual knowledge of it. The presumption is that if the party affected by any fraudulent transaction or management might, with ordinary care and attention, have seasonably detected it, he seasonably had actual knowledge of it. SS 381. Means of knowledge are the same thing in effect as knowledge itself, and are equivalent to actual knowledge, is the language employed in some of the cases, as applied to our subject at least. It is conceded that these statements are inaccurate, for guilty knowledge would of course defeat the purchaser's title, while the means of knowledge would not have that effect unless the duty to inquire was cast upon him. Again, while a preference would not be avoided under the late Bankrupt Act, by reason of a mere suspicion of the debtor's insolvency in the mind of the creditor, yet knowledge of facts calculated to produce such a belief in the mind of an ordinarily intelligent man would avoid the security. It may be urged that some of the citations given are from cases in other branches of the law than that governing fraudulent transfers. This may be true as to a few of the citations, but the mass of the authorities collated directly involved the question of notice of a fraud and an alienation made to defeat creditors. It is submitted that in no department of the law is there greater need for increased facilities to detect and unearth fraud than in that regulating covenants alienations, and therefore the cases illustrating other branches of the law are not irrelevant. Clearly the dictum of Miller J. already quoted, that circumstances to put the purchaser on inquiry where full value has been paid are not sufficient notice of fraud, cannot be supported or recognized as against this multitude of authorities. If the creditor is to be divested of the benefits of the doctrine of constructive notice, as the cases cited seem to indicate, then we contend that facts sufficient to excite inquiry or to put a prudent man upon his guard should raise a presumption of guilty knowledge or constitute prima facie proof of actual notice of the fraudulent design, which, in the absence of satisfactory explanation, should be conclusive. Constructive notice in this connection may be likened to the rule still prevailing in some states, to the effect that a failure to effect a change of possession on a sale of personalty is conclusively presumed to be fraudulent as to creditors. The doctrine which we advance is akin to the common and generally prevalent doctrine that continued possession on the part of the vendor is prima facie fraudulent. That is, raises a presumption which may be explained or rebutted. SS 382. Actual belief. There is another view, already outlined in part, to be taken of this question. In New York, fraud, in cases of alienations to defeat creditors, is deemed a question of fact and not of law. In Coleman v. Burr, the claim was made that there was no finding by the referee of a fraudulent intent, but that on the contrary he had found the whole transaction to be fair and honest. The court, however, observed that as the referee has found facts from which the inference of fraud is inevitable, and although he has characterized the transactions as honest and fair, that does not make them innocent nor change their essential character in the eye of the law. The assignor must be deemed to have intended the natural and inevitable consequences of his acts, and that was to hinder, delay, and defraud his creditors. There is nothing novel or unusual in this case. The principle it enforces is founded in public policy and is very frequently applied. It will be seen at a glance that under this rule of fraudulent intention can be conclusively fastened upon the debtor when no such wrongful motive was present in his mind, and he was as free from the design to defraud as our first parents were of knowledge of sin before tasting the forbidden fruit. From the necessity of the case, the substituted fraudulent intent prevails, because experience from which the rule springs has shown that transactions where this presumption obtains hinder and defraud creditors in enforcing payment of their claims. The difficulty of proving other than by circumstantial evidence that a vendee had actual knowledge of the vendor's fraud or participated therein is manifest. The law labels certain facts and combinations of circumstances as being sufficient to excite inquiry and suspicion on the part of a purchaser, and supplements this by asserting that in certain cases means of knowledge are the same thing as knowledge itself. The principle of imputing a fraudulent intent to an innocent debtor is frequently invoked. Is there any legal absurdity or moral wrong in imputing it to a vendee? Do not the necessities of the case often demand it? It is respectfully contended that the test, whether the vendee did in fact know or believe that the vendor intended to defraud his creditors, would furnish a very uncertain and fluctuating standard, and would not in fact constitute a general rule of any utility. The intellectual and moral perceptions are stronger or weaker in different men, according to their natures and education, and a man morally obtuse might look upon a transaction as honest which to the average person would appear to be manifestly unfair or fraudulent. We have seen that a man may commit a fraud without believing it to be a fraud. SS 383. Purchaser with notice. It is manifest that one purchasing of the fraudulent grantee with notice of the prior fraud takes the title subject to all the infirmities with which it was effected in the hands of his grantor. To hold otherwise would be equivalent to saying that three conspiring together might accomplish a fraud which would be impossible to two. Purchasers pendent light are bound by the result of the litigation. SS 384. Purchaser with notice from bona fide purchaser. It is a well-settled rule in equity that a purchaser with notice himself from a bona fide purchaser for a valuable consideration, who bought without notice, may protect himself under the first purchaser. The only exception to this rule is where the estate becomes revested in the original party to the fraud, in which case the original equity will reattach to it in his hands. A volunteer with notice, who derives his title from a bona fide purchaser for value without notice, is unaffected by the fraudulent character of the original transaction. This is necessarily the case. Otherwise, the party holding the perfect title might be unable to dispose of it, and its value would be greatly impaired. The party purchasing with notice recovers in the right of his vendor. SS 385. Fraudulent grantee as trustee. Elliott, J. observed in a recent case in the Supreme Court of Indiana that where property is fraudulently conveyed, the grantee holds it as trustee for the creditors of the grantor. In Blair v. Smith, the court said, Mrs. Smith received the money as trustee, and as such must account for it. If she had received a stock of goods from her husband pursuant to a corrupt scheme to defraud his creditors, she certainly could have been charged as trustee. The fact that she received one species of property rather than another can make no difference. The governing principle is the same, no matter what kind of property the fraudulent participant in the positive wrong receives. Mr. Pomeroy asserts what is well known to be the law, that a fraudulent grantee takes as trustee, and says the lien upon the original articles will extend to the resulting fund or the substituted goods. SS 386. Title from fraudulent vendee. It was at one time sought to establish the rule, at least in some of the authorities, that a bona fide purchaser from a fraudulent grantee was not entitled to protection against the claims of the creditors of the fraudulent grantor. The argument in support of this doctrine was to the effect that by the very terms of the statute against fraudulent transfers, the conveyance was pronounced utterly void, frustrate, and of no effect, and consequently a subsequent conveyance from the fraudulent grantee could have no foundation on which to rest. So, also, it was contended that it was against the policy of the statute to afford protection to a subsequent purchaser from the fraudulent grantee, though he parted with value, in ignorance of any infirmity in the title he was acquiring. Quoting the words of Chancellor Kent, though the debtor himself may fraudulently, on his own part, convey to a bona fide purchaser for a valuable consideration, yet his fraudulent grantee cannot, for it is understood that the proviso in the 13 Alis does not extend to such subsequent conveyance. The policy of that act would be defeated by such extension. Its object was to secure creditors from being defrauded by the debtor, And the danger was not that he would honestly sell for a fair price, but that he would fraudulently convey upon a secret trust between him and the grantee, at the expense of the creditors, if the debtor sells himself. In a case where the creditor has no lien and sells for a valuable consideration, he acquires means to discharge his debts, and it may be presumed he will so apply them, if his fraudulent grantee be enabled to sell. The grantor cannot call those proceeds out of his hands, and the grantee can either appropriate them to his own use or to the secret trusts upon which the fraudulent conveyance was made. There is more danger of abuse, and that the object of the statute would be defeated in the one case than in the other. The decree of Chancellor Kent was reversed on error, and it was dissented from in the contrary doctrine held by Judge Story. In Bean v. Smith, and now in nearly if not all the states, the doctrine is settled that a fraudulent conveyance will not, at the instance of the creditors, be vacated to the prejudice of an innocent purchaser from the fraudulent grantee. SS 387, Creditors of Fraudulent Grantee, in Suzong v. Williams. The court held that where a conveyance was made by a mother to her son upon a secret trust to reconvey to the grantor when peace should be re-established, the motive of the grantor in making the conveyance being fear of confiscation, the conveyance was valid between the parties, and the reconveyance, being without consideration, was void as to the creditors of the son. This is based upon the principle that the grantor, by making this conveyance to her son valid and effectual on its face, and permitting it to be recorded, thereby held her son out to the world as the owner of the property whereby he was enabled to obtain credit. The principles of this case would seem to render it unsafe for any owner of property to allow the title of it for any cause to rest in another person. Certainly it behooves the fraudulent debtor to exercise care and good judgment in selecting a vendee who not only will consummate the secret trust, but who will not be frustrated in so doing by his own creditors. This doctrine of apparent ownership may be variously illustrated. In Budd v. Atkinson, it appeared that a father bought a farm and caused it to be conveyed to his son by a deed which was recorded. The son entered into possession of the property and lived upon it. Subsequently, he contracted debts on the credit of his ownership of the farm. Then at his father's request he conveyed the property to the father, without consideration, and upon the ground that the latter had never intended to give the farm to him, and that the son was not aware that the conveyance had been made to him. The court held that the deed to the father was fraudulent as against the son's creditors. Where, however, a fraudulent mortgagee reconveys the land to the fraudulent mortgagor, before any lien attaches in favor of the creditors of the former, they cannot subject the land to the payment of their debts. SS 388, Liability between fraudulent grantees, in Riddle v. Lewis. The court decided that fraudulent grantees, as between themselves, incur no responsibility to one another by permitting the grantor to have or dispose of any part of the property conveyed. SS 389, Fraudulent grantee sharing and recovery, where a fraudulent scheme or purchase, under which a creditor obtained property of an insolvent debtor, is set aside in a suit brought by another creditor against the fraudulent vendee, the latter will not be allowed to share with the complainant in the proceeds of the property. But, as we have shown, where an illegal preference is set aside, the creditor who attempted to secure such preference is not necessarily thereby debarred from participating in a distribution of the debtor's property under a voluntary assignment act, including the property thus illegally conveyed to him. But, as we have shown, where an illegal preference is set aside, the creditor who attempted to secure such preference is not necessarily thereby debarred from participating in a distribution of the debtor's property under a voluntary assignment act, including the property thus illegally conveyed to him.